Hi friends, this is Lokesh Pathak with you, and today I'm going to start the class on Indian Contracts Act. So this is apart from one video lecture which is posted on my page, and that is for Indian Contracts Act Basics and Principles. But I would like to start the new fresh sessions for this, and this is my first session on this. And for Indian Contracts Act 1987, I would like to start with historical evaluation of the act. So it is good to know how the act came into picture and what was the scenario before this act in Indian as well as international perspective. So as we all know that Indian Contracts Act, it got enacted on 1st of September 1872. But how the contracts were governed before that in India as well as overseas. So for in Indian perspective, before 1872, the contracts were governed with the three basic principles, and that principles are more governed with natural law. These are equity, morality, and religious laws. As we all are aware, in our ancient times, the religious beliefs, myths, as well as our whatever is written in our Vedas, Shrutis, and Smritis, that had been a concern, and that had been the basis to decide the things in juridical manner. So, in Indian perspective, as I said, if somebody asks you that how the contracts were governed before 1872 Act, so we can say that it was based on equity, morality, and religious laws. And once 1872 Act was enacted, then because it was originated from English law, like Britishers were there in India and they enacted it, so definitely it was based on the common law principles that we all are aware what these are. These are equity, the same which was the basis of in the Indian law also. So there are four basic common law principles. These are equity, justice, good faith, and inner conscience. So this was the similarity. What was the basis of deciding on the contracts before the enactment of 1872 Act and after that. And as you are aware that Article 13(1) of our Constitution, it determines the validity of those acts which were in law in force, like the laws which were in force before 1950, which was enactment of our Constitution. So Article 13(1) says that whatever laws in force which are inconsistent with the Constitution, that will be void. So this act was not affected because it was not in contravention of Article 13(1) of Indian Constitution. So that is an important question if someone asks you that what was the changes, why this act was not repealed or not void, not declared void when Indian Constitution was enacted, because there was no contradiction of Indian Contract Act 1872 with the provisions or the fundamental rights or part 3 rights mentioned in our Indian Constitution. So hence it was not in contravention of Article 13(1) of Indian Constitution, and hence this act was kept on. It was still as a law in force. It was prevailing since then in the Indian environment. So now, what was a historical evaluation? If we see on a global perspective, we will start with Roman law, because what Romans were quite advanced with respect to legal systems. Because what Romans did, they had earlier they had a rigid legal system. So what they did, they transformed that rigid legal system into a cosmopolitan living law. That was the first achievement what Romans did from earlier Greek natural law philosophers. So that is a part of jurisprudence, but the basis of Contract Act, definitely it has to be originated from the jurisprudence. So Roman law, what they did, they transferred the traditional or the conservative or the rigid legal system into a cosmopolitan living law. And what they did, they decided to make three bases of laws. They divided law into three parts. One was jus civile, second was jus gentium, and the third was jus naturale. So jus civile was only applicable to Roman citizens, while jus gentium was mixed. It was applicable on Roman citizens as well as foreigners, and jus naturale was the ultimate development of those two laws and the other laws to make the universal law in Roman environment. So with these classifications, they moved, and when it came to the contracts, what they did, they divided the contracts into four basic type of contracts. Those were ipse random, sponsio, nexum, and dotis dictio. So they were used as per their relevance. Like ipse random, as per this type of contract, it was considered that the promise done by any party, it is considered that this promise is from God. So it was again related to religious laws and the divine things. So here with ipse random, if we talk about punishments, there were two type of punishments in this contracting. One was divine punishment and the punishment by person. So apart from the punishment by person, if we see divine punishment, so it again has a belief, it's again on a based on the religious laws, that if someone violates any contract, the God will punish him. So it's again a religious or moral aspect of contracting. Coming to sponsio, in sponsio, both the parties who were part of the contract, they were required to take oath in front of gods. So this type of contracting was again based on the belief with the ultimate existence of God, the morality, religious laws, natural law principles. Then the next contracting was nexum, Nexum, nexum. And this was generally done with the loan agreements or sales agreements. And in that, what was done, there were five witnesses which were called for, and the agreement was done in front of them. There was no written agreement, but those persons were the witnesses of that agreement. And the last one is the dotis dictio. As the name says, it was a marriage concept. It was related to dowry agreements. And in that agreement, the father of the daughter, he was required to declare the dowry amount in front of the persons in the marriage ceremony. So that was another type of contracting. Now from Roman, if we go to the Muslim law period, and it was like all the contracts, they were governed as per the concepts written in Quran. And based on this holy book, it was decided that any contract between parties is governed by Allah. And this was applicable to all prime sort of contracts, like property related contracts, marriage contracts, as well as inheritance contracts. Coming to the Hindu system, our basis of Hindu system is a prime basis of Indian law. So the contracts were governed with the stipulations mentioned in Manusmriti, Shrutis, Vedas, Kautilya's Arthashastra, Atharveda, etc. Coming to the British era, which gave the birth to 1872's Act, the first contracting principle was introduced by King George I through the Charter of 1726. And this contracting method was enacted in the presidencies of Madras, Bombay and Calcutta in India. Afterwards, in 1773, Regulating Act was enacted, and this was the basis, it was a foundation stone of Indian Contract Act 1872. This Regulating Act of 1773, it prevailed until 1862, because in 1861, the Indian Contract Bill was introduced, and this was the prime draft of the 1872 Act. This was having various heads like contracts, bailment, partnership, agency, sales of goods, guarantee, etc. So this act was kept on being discussed, and ultimately on 1st of September 1872, Indian Contract Act was enacted. It was basically an amended version of this 1861 bill. Finally, this act was having 266 sections. Brief I would like to give, because this will be the discussion in the next classes. So this act, which was finally in the form in 1872, this was having 266 sections. Section 3 to 75 was related to essentials of the contract. Section 76 to 123 was related to sales of goods, and this portion from section 76 to 123, it was repealed in 1923, and it was made a separate act, which is Sales of Goods Act. Then section 124 to 238 is again related to indemnity, guarantee, bailment, agency and pledge. I'm repeating, this is basically the contract 2 part, which is having section 124 to 238, and it is comprising of indemnity, guarantee, bailment, agency and pledge. The last part is section 239 to 266, which is partnership, and that is also being taken up separately. So this is the structure of the Contracting Act 1872 of India, and we related it with the traditional beliefs or the laws or the principles on which the contracting in India was taken care. And then we have seen that it was having no contradiction with Article 13(1) of Indian Contract Act, and that is why 1872 Contract Act, it is still prevailing even after the enactment of Constitution in 1950, because of no inconsistencies with the Constitution of India. Then we have seen the traditional way of contracting from Roman Empire. Then we have seen the Muslim law period coming to Hindu law, and ultimately what happened in India in the British era, which gave birth to this act. Now in the future classes, I would like to take up the details and the elements, because I'll first concentrate on section 3 to 75, which is essentials of the contract. So this we'll take up in the next session. Thank you. Stay connected to me. This is Lokesh. Bye.